Dear Mr. Sanyal, I heard your incisive speech on judiciary, and I am not part of that creed or would cry hoarse to initiate contempt proceedings against you because I, for myself, value freedom of speech more than anything else as a democratic norms. And we have a strong credos and principle of freedom of speech only because of a strong judiciary. You must keep in mind that the freedom of speech, which has been protected in this country, notwithstanding many other fallacies or many other weaknesses we have in this country, freedom of speech is stoutly protected by a higher judiciary, both High Court and Supreme Court. And it is sometimes, I must confess, imperiled and tinkered with by misuse, use, or wrong use of the investigating agencies, surprisingly, by your freedom of speech is curtailed by misuse of the agencies like the Enforcement Directorate, the CBI, and also in some cases the income tax. People are generally afraid that they should not speak frankly because they feel that they are vulnerable to if further on further possibilities of actions from the government. Uh, uh, you just to refer some points you have done in the speech in presence of uh, many eminent lawyers, judges, and other things. I must confess your concerns are genuine, but your reasonings may not be very accurate, though there are some substance in your reasonings also. To start us, let us talk of commercial courts and your statement that unfortunately commercial courts are the matters are pending for long and only because it is made compulsory that premeditation mediation between the parties is made compulsory, which benefits the lawyers more than anybody else. Mr. Sanyal, the concept of compulsory premeditation, so mediation, I'm sorry, is I'm not as I can't speak so well as you do, but I am trying to keep across my point to your benefit or benefit of some people who'd like to hear it. That this concept of is introduced under Section 12A of the Commercial Courts Act by a statutory provision. Now, you can't blame the lawyers and judges for following the statutory provisions. The government whom you represent has enacted the statute through the parliament, and hence you should be advising the government to amend the statute. And I also agree that it should be made voluntary and optional, not compulsory. By making it compulsory, in 99% cases, as such, it fails. So, hence, there is a delay in commercial courts. So, please advise the government that they should make necessary amendments in the statute. Now, there's some other provisions I would like to bring to your notice. That since you're talking of delays in judiciary or judicial decisions have several factors. It includes you can blame the lawyers for taking time, adjournments. You can blame the judges for not doing their work properly or not doing very seriously, or you can say that their disposal rate is very less. But this is not important. It should not depend on the ability or disability of an individual. It should be depending on the system. And our system is, unfortunately, I mean, most of the systems, as you know, as from the British time, that in a civil matter, we have multiple tiers of appeals. Like we have from the start from the lower judiciary, that is called the civil judge junior division. There's an appeal to the district court. There's an appeal to the high court. That's called second appeal. And there's also an appeal further to the Supreme Court in a matter of SLP or filing an appeal in the Supreme Court. Now there are four appeals. Similarly, in criminal matters, we have large number of appeals from lower court to district court, from district court to high court, and also to Supreme Court. There is also a lot of interlocutory matters and the matters are stayed because of revisions, 482, petitions under 482, and all these procedures. So it needs a serious introspection by the government, probably in consultation with judiciary, that what should be the procedure by which matters are decided. Kindly keep in mind, like anti-corruption cases. I was a prosecutor for CBI for 14 years, and I know the procedure that for a CBI case to reach a conclusion, 90% of them take 25 years to a minimum 20 years, finally 20, maybe 25 years, or maybe may not be decided ever. And in 90%, I mean, large number of cases, the matters get abated because the accused dies during the pendency of proceedings, either in the original court or in the appellate court or in the higher courts. Now, this is not the ideal procedure by which, in fact, in the CBI cases, I've realized investigations sometimes take 2, 3 years. There's a matter of sanction, it takes a long time. Then after the sanction, there's a charge, there's a discharge, there's a procedure. So all this procedure, there's a compelling need to look into the procedural matters of in matters of trial, matters of. In fact, an interesting thing I will share with you. In before the district court Puri, when I was present for a matter, I was found out that before the accused could say anything, the judges starts writing, "It is not a fact." That means they know that the accused is not going to support the case. I'm sorry, not the accused, the witness. The witness is not going to support the prosecution case. And they automatically write it's not a fact because they know it. The 90% of our witnesses are gained over in criminal cases. And in the process, they do not succeed. But in fact, I'm tempted to say, recently I heard the great erudite and great scholar, Mr. Hari Salve, stating in a conference with in the Republic TV, said that Supreme Court's overreach, and said that most of the cases where Supreme Court has intervened, like 2G, that Jain Hawala and other things, all have resulted in acquittal. My personal belief, my personal view is the conviction of a case doesn't mean there is no truth in it. That means a person can be acquitted because of lack of evidence, lack of conclusive evidence, and lack of faulty prosecution, lack of many other things, and maybe also by the ability of the judges, the lawyers who defend the accused. That's also important. But that doesn't mean there's no truth in it. Truth is different from conviction. That means if a person is not convicted, that doesn't mean there's no truth in that allegation. So if Supreme Court is intervening in matters of public interest, especially in matters of corruption, it is why the need is because people have lost faith in many institutions, and hence they are depending on Supreme Court. It may be misused by somebody, it may be a matter of blackmail by somebody, but fact remains that the Supreme Court is interfering only because there's a need to, because our system has been corroded. Our system has been corroded by a system by which economic, politics, violence all go hand in hand, and corruption has assumed great proportions. And this hence, please advise the government. Please advise the government that it is absolutely necessary that the procedural laws may be amended substantially, so that the corrupt doesn't escape and the innocent doesn't suffer. Now we have a system where the innocent is afraid of law, the corrupt are not. The persons who are corrupt, the persons who have transgressed the law, are absolutely, they know that they can get over the system by prolonging the litigation because of the procedures we have. In fact, I'm absolutely we're in the same pace, and I'm equally concerned with the development of a country, state, people in every sphere. In fact, may I take a pause, Mr. Sanal? I heard your speech and I really appreciated the manner in which you spoke. In fact, if you would have been in the legal profession, you would have been a very, very successful lawyer. But let me tell you, as far as the legal system is concerned, it is not necessary that you have to be a lawyer to argue your own case. That is a concept of petitioner in person is there from every court, starting from the lower court till the Supreme Court. You can argue your own case. Lawyers are nothing but the power, like some sort of a power of attorney holder of the of the clients of the petitioners, that they represent them in the forum of court, and they have some matters of educational background, some set of responsibility as officers of the court, for which they are the category who represents. But otherwise, you can argue your own case. And Mr. Sanyal, and I mean, I hope there's no need for you to ever argue your own case. But if that be so, please, you can argue your own case. And in fact, your allegation is that there's a rift and conflict between the induction of two categories of judges in the especially in the High Court. One from the they are not they should not be said as subordinate judiciary or a lower judiciary, but from the cadre of district judges, there is a elevation to the Supreme Court, and from the directly from the bar, there is there persons are appointed by the system, as we know, followed by the recommendation by the Chief Justice of the High Court, and thereafter by acceptance of the collegium of the Supreme Court, and thereafter the appointment is made by the government unless they have differing views. You say there are difference of sort of status, difference of angularity, different of attitude between the person who is elevated from the district judge cadre and the persons who are, I mean, lawyers who are elevated directly from the bar. Yes, there is. No doubt there is. Mr. Sanyal, unfortunately, we have a system in the country. There has to be some differences between two categories. Like in Indian administrative service, if you are from the promoted quota and the direct quota, there is differences. If you are from the reserved quota and a general category, there are differences. If you are a person belongs to the same state cadre, that means if in Odisha you belong to Odisha, or you are from outside, there is differences, and there are differences, and these differences are there in every service. And unfortunately, I appreciate your concern, but I have a suggestion for the consideration of the policymakers in the Supreme Court Collegium, that probably if you make it 50-50, it will be more balanced, like 50% from the district judge cadre and 50% from the bar. Because if you can't make it only one, that is, if you are only from the subordinate judiciary, oh, I'm sorry, so not subordinate judiciary, from the district judge cadre, then there will be possibly the persons, the best of the talent may not be attracted. If it is from the bar only, there will be great frustration in the judiciary, from the cadre judiciary, that they don't have an ample future and opportunity. So this balance is absolutely required. 50-50% would be an ideal, according to my suggestions. And here, may I say that if you have to improve in every system. The suggestions of yours, suggestions of anybody, is very much required for improvement of any system. And the government should be, and the judiciary should be amenable to suggestions. And there are so many scope for improvement. And everybody, and in fact, it should be a matter of serious concern of the Supreme Court Collegium, that what should be the balancing intake from the judiciary, from the subordinate judiciary, I'm sorry, making the word subordinate decision from the district judge cadre and from the bar. Uh, uh, Mr. Sanyal, you have serious objections to vacations of the courts. We, in fact, broadly speaking, there are three vacations. One is summer vacations, bigger vacations, summer, then there's a winter, then there is a Holi, and there is a Diwali, possibly. These are, and other holidays are there. You feel that vacations, policeman acts round the clock, the doctors work round the clock, all the year. Why should the judges and the lawyers should have vacations? There's a slight difference, Mr. Sanyal. The judges and the lawyers. So let me tell you an example of a lawyer, since I am a lawyer for so many, more than 40 years, 45 years for that matter, that the lawyers work in the morning, they if they have work, and many of them, many of them have work, and if the lawyers work from the morning, they prepare for the case. They also deal with some last important points to be discussed with the clients, and thereafter they sit in the court almost from 10 to 4, irrespective of whenever the matter reaches. They can't go home and come back. And after 4:35, after a mild relaxation, they again 6:30, they sit down in the office and again prepare for the next day, prepare for the case, deal with the clients, settle the petitions or draft the petitions depending on your experience. And so far as the judges are concerned, the judges also in the morning they go to the courts, they sit down from 10 to 4. Most of the judges, especially in the high courts, they from 4:30 to 6:30 they correct the orders which they have dictated, and 6:30 they go home, and thereafter they prepare for the next day. They prepare for the cases, they write judgments. In fact, in the working days, almost the judges work for say 12 to 14 hours a day, whoever are sincere, of course. And especially they also take time to prepare for different legal meetings, conferences, journals, etc. So you can't equate them with other things, and it's like you don't have schools and colleges for 365 days. You also have vacations of schools and colleges. The professors also have vacations in the where they prepare themselves, they write journals, they write articles, they guide their students. So similarly, you can't equate us with the policemen in the streets. Unfortunately, the policemen are working more than they should, but that's a different matter. That's a different story and a different day. We'll talk about it. So far as the judges, so far the lawyers are concerned, and the judges are concerned, yes, there is a need for reducing the vacations. In fact, the Supreme Court has started this practice of also hearing regular matters in summer vacations, and they call it a restricted working or a restricted holidays, but they have started working. In fact, the high courts have also taken up more matters in the vacations than they used to. So these are the matter also requires serious introspection, where they could reduce or increase the workload in the vacations. I appreciate a concern, but these are matters which you should not blame straight away. Now, Mr. Sanyal, you made this reference of three categories of lawyers. One is a general normal lawyer, one is a senior advocate, and another is an AOR. In fact, let me start with AOR. AOR is called Advocate and Records. It's a system in Supreme Court where a person with certain years of eligibility can appear in exams conducted by the Supreme Court, so that he will be the person who can only file a petition. Well, the need of having an AOR is that a person should have minimum knowledge of the procedure and the law before he files a petition in the Supreme Court. Otherwise, the Supreme Court will be flooded with many petitions, and there is no sense of responsibility in filing a petition in the Supreme Court. So that is the reason we have a system of advocate record. Now, second is normal. Anyway, everybody is a lawyer, but some of them are designated as a senior advocate by the High Court, all high courts, and Supreme Court. Now, this designation of as a senior advocate is a concept by which a person is recognized for the services he has done for the judiciary and for the legal profession, and for a sen he'll be sen sage. He'll advise the younger generations, and it's a recognition. Like I mean, in the academics, you have professor emeritus, you have honorary doctorates. These are all recognitions. This is also a recognition. So, I mean, still, if you have any objection to having that, in fact, I am a senior advocate for last 22 years, and I feel that the system is a necessity by which a person gets, he is there to guide the juniors and to guide the younger generation. But if you still have, all of you have objections to the system of senior advocates, then I mean, we are prepared to hang our gowns, but we will continue to work for the judiciary, continue for the betterment of the judiciary, and I mean, we will be there, irrespective whether you give us a gown or don't give us a gown. Uh, yeah, I will say some other things like you. I'm before as a senior advocate have said, and now uh, you have an objection to the use of the word prayer in the petitions filed in the courts. I personally feel, so far as prayer is concerned, it's a very respectful word. In fact, the word prayer is there in everywhere. You make a representation to the government, you say that prayer. It's a prayer. It's a respectful word. There's nothing called how do you substitute the word prayer? Instead of prayer, what is that? You can't say that, do it. It's a normal, respectful, because India is used to showing respect to everybody. As far as addressing judges as lords, in fact, long since they have discontinued the concept of lords, and they have always suggested to call and address them as sir. But in fact, most of us do address as sir, mostly. But the concept of lords, they're still being addressed as lords. It doesn't probably possibly make any difference to a judge whether he's addressed as a lord or a sir. But fact remains that, Mr. Sanyal, habits die hard in this country. There's no red light culture. The red light has been abolished. But have you seen any vehicle of government which does not carry an insignia, like from Tehsildar to the chief secretaries or the secretaries government? Everybody has an endorsement that what is the status of the person who is traveling in the vehicle. So is that this is substitute for the red light? So the red light culture has not gone. Instead of red light, you have insignia. Everybody is starting from sub-collectors, the tehsildar, and in fact, even, it is unlimited. I mean, everybody writes MLA, MP, everybody writes his own insignia in the, and it's a substitute for the red light. And it's a easy way to go to the toll gate without paying the toll tax. That's how it's die hard. But however, we all call the honorable judges as sir. I hope you don't take to exception to the my saying that honorable judges. In fact, I'm very proud, as you are, in that India is heading towards to becoming the third largest economy in the country, and we are I don't dispute some judicial orders is a handicap to development, especially injunctions and stays without proper justification is in contract matters of the government where development is stalled. But unfortunately, Mr. Sanyal, our country is not a very, we are not famous to be a honest country. There are a lot of corruptions, lot of what do you call A lot of corruption has partiality has subsumed our country, and in fact, in every sphere you find some amount of that is not based on justice. Some people get benefit more than the others, and in fact, to that extent, judiciary is the last bastion to control these illegalities in the government of the society, while all other pillars of the government are okay, stable, but they are not in the best of the health, and they need some corrections, more corrections than the judiciary, and and in fact, I personally believe if we don't have a system of the government and the president's palace being occupied by the Gen Next, as it happened in Bangladesh, as it happened in Sri Lanka, as it happened in Nepal, because of the strong foundation of our constitutional system, particularly our judicial system. And I have a lot of respect of judiciary, though there is always a scope to improve the system. Mr. Sanyal, I may also make another prayer to you, and you that the idea of a Viksit Bharat, the idea of a Viksit Bharat is not that you have the third largest economy, but the idea of Viksit Bharat is how much a percentage of our people are below poverty line or are on the verge of poverty, are suffering the on account of poverty. That's a very important matter. Is don't please the government should not take credit how much of doles they're giving to that people, but how much of less number of people require doles is so important. It's not that I'm giving the rice, the free education, the free medical. They are important, but more important is how many people less require that. How many people go beyond that to the higher level where they don't need the support of the government, and they can and let us build a system and improve all our systems. Let us build our nation. We are, and I am always available for any sort of help you need from me. Help in the sense, it's not help, it's my duty to improve our nation, our polity, and our system. God bless you.